Counsel, you did not challenge below the legal standard that the First Circuit uses, right?
Not explicitly, Your Honor. We've obviously resisted the finding of persecution here. We think that argument.
But you didn't say that they've used the wrong definition. I actually don't understand why a credible death threat would not always cause suffering or harm, and the other side will respond to that. But you didn't say that. You've been arguing something quite different.
We did not make that argument explicitly before the First Circuit. I think it's fairly subsumed in the question of whether do these facts, as they are, demonstrate persecution. And again, on remand, we would make that argument.
As far as I understand the government's position, if you had challenged the standard, they would say that's a legal question that the court would have looked at. But because you didn't, you were actually arguing the facts, that these facts showed enough suffering or harm. I think that's their position.
I do think that is the government's position, but again, below, we were up against the substantial.
Do you lose if I accept what the government says?
No, Your Honor, because in the First Circuit, they cabined their review entirely to deference to the BIA, and like many other courts of appeals, they have not taken the same position as the government that a question like that would be reviewed de novo.
You're saying we have to look at that question.
Correct.
We have to decide that.
Not in the first instance, but remand so that we can advance it. Maybe the government has a waiver argument. Maybe they argue that we didn't waive it because there was First Circuit precedent on point, but we need to go on bonk. We'll have that fight on remand, but it's not something this court should resolve in the first instance.
Thank you.